You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The U.S. privacy system is deeply shaped by the three-branch structure of the Constitution, with each branch playing a distinct governance role. The legislative branch creates statutes that define specific privacy obligations. The executive branch implements and enforces those laws through agencies and policies, and the judiciary interprets the laws and resolves disputes. Unlike systems where a single authority governs privacy comprehensively, the U.S. model disperses responsibility, producing a patchwork of sectoral laws and enforcement mechanisms. This division ensures checks and balances but also creates complexity, as multiple authorities may influence how a single privacy issue is resolved. For exam candidates, understanding these branch-specific functions is essential because exam questions frequently frame scenarios in terms of who has authority to create, enforce, or interpret privacy obligations. The legislative branch exercises its privacy authority through lawmaking. Congress enacts statutes that govern specific industries or practices, such as HIPAA for healthcare, GLBA for financial institutions, and COPPA for children's online data. Congressional committees play central roles in shaping these laws. The House Energy and Commerce Committee and the Senate Commerce, Science, and Transportation Committee are particularly influential in consumer privacy, while the House and Senate Judiciary Committees focus on civil liberties and surveillance oversight. For learners, remembering committee jurisdiction underscores that privacy legislation is not concentrated in a single body but divided across several, each with its own emphasis. This fragmentation often explains why federal privacy legislation emerges incrementally, focusing on specific concerns rather than comprehensive frameworks. The bicameral process adds another layer of complexity to privacy lawmaking. Both the House of Representatives and the Senate must pass a bill in identical form before it becomes law. When versions differ, conference committees reconcile the texts, producing a unified version for final approval. This process often results in compromises that shape the scope and applicability of privacy statutes. For exam purposes, recognizing the bicameral structure explains why privacy laws often contain negotiated language that reflects competing interests. It also illustrates why comprehensive privacy reform has proven difficult. Agreement must be reached not only across parties, but also across chambers with distinct legislative cultures and priorities. Within the executive branch, the Office of Management and Budget coordinates policy across federal agencies. OMB plays a role in ensuring consistency in how agencies collect, use, and protect personal data, particularly in federal information systems. For learners, the key term is coordination, reflecting OMB's responsibility for aligning agency practices with overarching privacy and security policy. This illustrates how executive oversight functions extend beyond enforcement to include harmonization of federal agency activities. On the exam, scenarios referencing federal policy frameworks may hinge on recognition of OMB's cross-agency role in implementing privacy strategies and setting standards for government handling of data. The Administrative Procedure Act governs how federal agencies create rules that implement statutes. Agencies such as the FTC, FCC, and HHS use rulemaking authority to translate legislative mandates into detailed operational requirements. The APA requires public notice, opportunity for comment, and reasoned explanations for final rules, ensuring transparency and accountability. For candidates, the key terms are notice and comment rulemaking and administrative law. Understanding this process helps explain why regulations evolve and how stakeholders can influence their shape. On the exam, questions may test whether candidates recognize the APA as the framework through which agency-level privacy rules gain legitimacy and enforceability. Independent agencies like the Federal Trade Commission and Federal Communications Commission hold special significance in privacy. These bodies are designed to operate with autonomy from direct executive control, often featuring bipartisan commissions and staggered terms for leadership. This structure is intended to insulate them from political shifts while ensuring accountability through congressional oversight. The FTC, with its broad consumer protection mandate, is the most influential privacy regulator. The FCC oversees telecommunications and marketing practices. For exam purposes, recognizing the independence and accountability of these agencies is important because it explains their enduring role in privacy even as administrations change. The Federal Trade Commission is perhaps the most important federal privacy enforcer. Its authority under Section 5 of the FTC Act allows it to act against unfair or deceptive practices. In privacy contexts, this includes pursuing organizations that misrepresent data practices or fail to implement reasonable security. Remedies include consent decrees, fines, and ongoing reporting obligations. For candidates, FTC terminology is central. Unfairness refers to practices causing substantial harm without offsetting benefits, while deception involves false or misleading statements. On the exam, scenarios may describe a company's failure to honor its privacy policy, signaling an FTC enforcement pathway under UDAP principles. The Federal Communications Commission provides oversight of telecommunications and marketing privacy. Its jurisdiction includes rules on customer proprietary network information and restrictions on robocalls and text messaging under the Telephone Consumer Protection Act. For learners, the FCC represents a more technical regulator focused on communications channels. On the exam, FCC terms may appear in questions about telecommunications privacy or marketing limits, requiring candidates to distinguish the FCC's narrower scope from the FTC's broader consumer protection mandate. This distinction illustrates how different agencies carve out roles within the larger patchwork of privacy regulation. The Department of Health and Human Services plays the lead role in enforcing HIPAA. Its Office for Civil Rights investigates complaints, conducts audits, and issues penalties for violations of health privacy and security rules. For candidates, the key terms are HIPAA Privacy Rule and Security Rule, each with distinct requirements but both enforced by HHS. Exam questions may test recognition of HHS's role as opposed to the FTC or other agencies. Understanding HHS's authority reinforces the sectoral nature of U.S. privacy law, where specific agencies enforce statutes tailored to their domains of expertise. The Department of Commerce, while not a direct enforcer, plays an important role in coordinating international privacy frameworks. It has historically managed cross-border transfer programs such as Safe Harbor and Privacy Shield, and supports the development of NIST privacy frameworks. These frameworks provide voluntary but widely adopted guidelines for managing privacy risks. For exam purposes, Commerce and NIST terminology highlights the role of standard setting and international negotiation in privacy governance. Learners should recognize that while Commerce does not enforce penalties, its frameworks and programs shape compliance strategies for organizations engaged in global data flows. Banking regulators, including the Federal Reserve, the Office of the Comptroller of the Currency, and the Federal Deposit Insurance Corporation, oversee privacy obligations in financial institutions. Their role includes issuing supervisory guidance and ensuring compliance with statutes such as GLBA. For candidates, the key term is supervisory authority, reflecting the power of regulators to evaluate, audit, and penalize financial institutions. Exam questions may test which regulators apply in specific financial scenarios, underscoring the importance of mapping obligations to the correct agency. This again reinforces the theme of fragmentation. No single regulator covers all privacy, but sector-specific agencies provide deep oversight within their areas. The judiciary interprets privacy statutes and constitutional provisions, shaping the meaning of privacy protections through precedent. Courts evaluate challenges to agency rules, resolve disputes over statutory scope, and interpret constitutional claims involving surveillance or data access. Judicial review of agency actions ensures that rulemaking remains consistent with legislative intent and constitutional principles. For learners, the key terms are interpretation and precedent. Federal court decisions bind lower courts and create nationwide standards. On the exam, scenarios may test whether candidates recognize the judiciary's role in shaping privacy through both direct rulings and review of agency actions. This highlights how the legal landscape evolves continually through case law, not just statutes and regulations. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Federalism adds another layer of complexity to U.S. privacy law. While Congress enacts federal statutes, states retain significant authority to legislate in areas not expressly preempted. This creates a dynamic in which state and federal laws may overlap or diverge. For example, while HIPAA governs health privacy nationally, states may impose stricter standards on providers within their borders. For exam purposes, the key idea is dual authority. Both national and state governments may regulate privacy, but conflicts must be resolved through preemption doctrines. This system reflects the broader constitutional design of shared power, where innovation often begins at the state level before influencing national policy. Learners should remember that compliance strategies must consider both federal and state obligations simultaneously. Preemption doctrines determine how conflicts between federal and state laws are resolved. Express preemption occurs when Congress explicitly states that federal law overrides state provisions. Implied preemption may arise when federal regulation is so comprehensive that no room remains for states to act. In privacy, preemption often limits inconsistent state laws while still allowing stricter standards in certain areas. For candidates, the key term is conflict resolution. Exam scenarios may describe overlapping obligations, testing whether learners can identify when federal supremacy applies. Understanding preemption is crucial because it dictates whether state innovations survive or are displaced, directly shaping the patchwork of privacy protections across the country. State attorneys general wield significant authority in enforcing privacy law. They often coordinate multi-state investigations, particularly after major breaches or widespread consumer harm. Settlements may include fines, injunctive relief, or mandated program changes. For exam candidates, the critical terms are investigation and settlement authority. Multi-state actions demonstrate how states amplify their power by acting collectively, effectively creating nationwide enforcement even without federal action. Learners should be prepared for scenarios where state attorneys general play leading roles, especially when federal agencies are limited by jurisdiction or political constraints. This reinforces the decentralized yet powerful nature of state privacy enforcement. The California Privacy Protection Agency stands apart as the first dedicated state-level privacy regulator with rulemaking and enforcement authority. Unlike attorneys general, who balance multiple legal domains, the CPPA focuses exclusively on privacy. Its functions include issuing detailed regulations, conducting audits, and bringing enforcement actions under California's privacy statutes. For exam purposes, the key terms are rulemaking and enforcement. Candidates should note that California's influence extends beyond its borders, as companies with national operations often adopt California standards as a baseline. The CPPA illustrates how states are not only filling gaps left by federal inaction, but also setting new national benchmarks through proactive regulation. State departments of insurance add another layer of oversight by supervising data practices in the financial and health-related insurance industries. Their responsibilities often include preventing unfair discrimination, which intersects with privacy when personal data is used in underwriting or claims decisions. For learners, the key terms are supervision and discrimination limits. Exam questions may test whether candidates recognize the insurance regulator's role in shaping privacy practices. This demonstrates how privacy enforcement often emerges in specialized domains, where regulators focus on sector-specific risks and ensure data use aligns with fairness principles. Understanding these roles highlights the breadth of privacy oversight across state institutions. The Department of Justice participates in both civil and criminal privacy enforcement. Civil actions may involve enforcing compliance with statutes like HIPAA, while criminal prosecutions can target willful violations such as identity theft or fraud involving personal data. For exam candidates, the key distinction is enforcement mode. Civil remedies address compliance, while criminal enforcement punishes intentional misconduct. Scenarios may test whether learners recognize DOJ's dual roles, highlighting that privacy violations can carry not only regulatory penalties but also criminal liability. This underscores the seriousness of data misuse and reinforces the need for organizations to implement both preventative and corrective measures. Interagency coordination is increasingly common in privacy enforcement. Agencies often sign memoranda of understanding to share information, coordinate investigations, or pursue joint actions. For example, the FTC may coordinate with the CFPB in cases involving financial data. For candidates, the key terms are coordination and joint enforcement. Exam questions may test recognition of scenarios where multiple agencies act together, emphasizing that privacy enforcement is not siloed but collaborative. This reflects the complexity of modern data ecosystems, where overlapping jurisdictions require agencies to combine expertise and resources to achieve effective oversight. The Global Privacy Enforcement Network illustrates cross-border cooperation in privacy enforcement. Regulators from multiple countries collaborate to investigate multinational companies and share best practices. For learners, the key idea is international cooperation. Exam scenarios may test whether candidates recognize that enforcement is not confined within U.S. borders, but involves global coordination. This reflects the reality that data flows transcend national boundaries, requiring regulators to align their actions to address global companies. Understanding this term prepares candidates for questions that situate U.S. privacy within the broader international context. Unfair and deceptive acts and practices are enforced at both federal and state levels. The FTC uses Section 5 authority, while state attorneys general often pursue cases under their own consumer protection statutes. This dual structure creates overlapping enforcement, where organizations may face scrutiny from both federal and state regulators for the same conduct. For exam purposes, learners should remember that UDAP enforcement extends across jurisdictions, amplifying accountability. The key terms are unfairness and deception, each with precise legal definitions. Recognizing how these principles operate in both federal and state contexts ensures candidates can navigate questions about enforcement pathways with accuracy. Private rights of action represent another important enforcement mechanism, allowing individuals to sue for privacy violations. These actions can escalate into class litigation, creating significant compliance risk. For example, Illinois' Biometric Information Privacy Act has led to large settlements because it permits individuals to sue directly. For candidates, the key terms are private right of action and class litigation. Exam scenarios may test whether a statute allows individual enforcement or restricts authority to regulators. Understanding this distinction is crucial because it determines who may bring a claim and how large the potential liability may be for organizations. Common law privacy torts provide judicially created remedies outside statutory frameworks. The classic categories include intrusion upon seclusion, appropriation of name or likeness, public disclosure of private facts, and false light. These torts remain relevant because they offer individuals recourse even in the absence of specific statutory protections. For exam purposes, recognizing these terms is essential because they demonstrate how privacy rights can emerge from judicial precedent. Exam questions may describe conduct such as surreptitious surveillance or unauthorized publication of personal information and test whether candidates identify the applicable tort. These remedies illustrate the flexibility of common law in addressing evolving privacy harms. Administrative adjudication occurs within agencies themselves. When organizations challenge enforcement actions, agencies often resolve disputes through internal administrative law judges before appeals proceed to federal courts. Consent orders represent another outcome, requiring organizations to commit to ongoing compliance and reporting. For learners, the key terms are adjudication and consent. Exam questions may test recognition of these processes, emphasizing that enforcement does not always proceed directly through courts. Administrative pathways highlight how agencies combine rulemaking, enforcement, and adjudication within their own structures, reflecting the multifaceted nature of regulatory authority. Self-regulatory programs and trust marks play supportive roles in privacy accountability. Programs such as industry codes or certification schemes create voluntary standards, while trust marks signal compliance to consumers. Though not substitutes for statutory obligations, they provide evidence of accountability and may influence regulatory scrutiny. For candidates, the key terms are self-regulation and trust marks. Exam questions may test whether learners recognize the difference between mandatory compliance and voluntary accountability models. This reinforces the principle that privacy governance involves both legal requirements and market-driven initiatives that shape organizational behavior. Organizations often find themselves accountable to multiple overseers in complex regulatory environments. A single company may be subject to FTC oversight, state attorneys' general investigations, sector-specific regulators, and self-regulatory frameworks simultaneously. For learners, the key term is accountability to multiple overseers. Exam scenarios may describe overlapping enforcement and test whether candidates recognize the need for multi-jurisdiction compliance strategies. This illustrates the reality that privacy is not managed through a single lens, but requires navigating a network of regulators and frameworks. Understanding this complexity equips candidates to approach exam questions with an appreciation of the layered nature of U.S. privacy governance. By synthesizing the roles of all three branches with federalism, enforcement doctrines, and private litigation, candidates gain a complete picture of how privacy governance operates in the United States. Mastery of these terms ensures readiness not only for exam scenarios, but also for the real-world challenge of designing compliance strategies in a fragmented, multi-jurisdiction environment. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.